We're ready to proceed, Sir John.
Thank you. Mr. Sanders.
Good afternoon, sir. Can you hear me okay?
I can indeed.
Excellent, thank you. I know your team is aware, but you might not be aware that I'm in fact on leave at the moment, and when these hearings were originally listed for before Christmas, and I had last week and this week booked off. So I've done my best to read all the other closings yesterday, but there's only so much I could do. But I'm really going to stick to my script in any event.
Can I apologise for interrupting your leave and express my gratitude to you for coming back in when really you ought to be putting your feet up.
Yes, well, not at all. It's no problem. Thank you, sir. So what I'm going to do is follow broadly the outline of our written closing. So to deal with the main body of the closing first, and then turn to the legal framework submissions. I'm not, of course, going to attempt to read through everything. I will just try and pick up some key themes and headlines. And so starting with the point that I'm going to come back to in terms of the legal framework, we've given you an outline of what we say that you, the inquiry, can do in relation to the legal framework. And then at the end, I'll turn to what we say you cannot get into. So in our submission, it is quite right and proper for the inquiry to take account of the legal framework within which the SDS was operating, so far as that's clear and uncontentious. And the propositions that we say meet that description are as follows, and they're really as regards the rights of individuals, the corresponding duties of the police, and also the powers of the police. So starting with the rights of individuals, there's of course the right to demonstrate peacefully, and that's a right of all citizens, whatever their view. So the right of far left groups to demonstrate and protest is precisely the same as the right of far right groups to do so, unless of course they are proscribed organizations. Accompanying that, there's the right to hold and attend election meetings on public premises, and there's also the right of other citizens who don't wish to demonstrate or protest to go about their ordinary business without let or hindrance. So those are the rights that the police must respect, and the corollary of those rights are the following duties of the police. So first is the duty to maintain public order and to prevent disorder, and there are of course two limbs to that, two sides to that coin. But maintaining public tranquility, the king's peace, is one part of it, and ensuring that that is not destroyed and that there isn't disorder, and quelling disorder is another part of it. The second key duty that the police had, and still have, of course, is to prevent and detect crime, and there are various public order offences that were in force at the time and relevant at the time, which of course it was for the police to enforce. And then the final duty we just mentioned and pick up on is the duty of police special branches, in this case in particular the Metropolitan Police Special Branch, to assist and support their uniform colleagues in policing public order, and B, MI5 in dealing with espionage, subversion, and extremism, and national security matters generally. So those are the duties that the police were under. And then just in terms of their powers, in particular, we pick up, of course, there were the powers that the police had under the Public Order Act 1936 in relation to processions. So they had the power to impose conditions on processions, not on any and every protest or demonstration, but moving non-static protests and demonstrations, and also to ban them. And those powers were exercisable in advance, which would obviously require intelligence upon which to exercise those powers, and they would also be exercisable in response to unfolding situations on the ground. And then the other power that the police had, relevant power, was the permissive common law power to do anything that wasn't prohibited. So that's what we say the framework, the legal framework was, insofar as it's clear and uncontentious and should be taken into account by the inquiry. The key point arising out of all of this in our submission, sir, is that the police were faced with a very difficult balance to strike, that they were obliged to facilitate demonstrations and also simultaneous counter demonstrations. They were obliged to treat the far left and the far right, anyone in between or outside of that, in the same way. And they had to do that while also ensuring that those not interested in politics or Marxism or fascism were able to use the highways and the public spaces and go about their business as they saw fit. So there's a very difficult balance for the police to strike there, and that's what we say comes out, you can see from the legal framework. In terms of the public order problem, we start our submissions with this observation, which comes from our clients, that they feel that there is a heads I win, tails you lose theme to the inquiry's proceedings, whereby an absence of violence or an absence of serious disorder is taken to suggest that there was no need for public order intelligence, and the occurrence of violence or serious disorder is taken to indicate that the intelligence was ineffective and therefore pointless. And we say that it proceeds from a false premise. There was, in fact, during the 1968 to 1982 period, a very serious and escalating public order problem, particularly in the capital. And that subsisted in a very high number of public order events, particularly political public order events, with a very high potential for disorder. And while it is true that for the most part, the Metropolitan Police was able successfully to avoid a repeat or recurrence of what happened in Grosvenor Square on the 17th of March, 68. That was not because the problem went away or evaporated. It was because of the steps that the Metropolitan Police took to address the problem and to maintain itself on top of the problem on an ongoing basis. And there were really three parts to that, those measures. The first was the establishment of A8, so a specialized public order branch that would coordinate across the force, pull officers from divisions and deal with public order events. Secondly, the development of specialist training for officers on public order duties. And then latterly, the development of specialist equipment, particularly the protective shields. And then thirdly, and importantly from your perspective, sir, was the establishment of the SDS as a resource to significantly improve the intelligence that the special branch was able to provide A8 in connection with its management of public order. And we've returned to some of the statistics we set out in 2020 in our first T1 P1 opening, sir. And I just remind you of the bare headlines there. Between 1968 and 1982, there were thousands of significant public order events in London. There were thousands of arrests at those events. There were thousands of injuries to police officers at those events. and there were also hundreds of injuries to civilians. And this all, in our submission, speaks of as we say, a very serious public order problem that the police needed to maintain keep on top of. Also looking at the statistics there, what one sees is that there was an increase across the T1 period in events requiring the deployment of more than 100 officers, from just over 1 a week to just over 1 a day by the end of the T1 period. But one also sees, alongside that statistic, that events requiring the deployment of more than 50 officers remain relatively stable. So in the region of 400 to 500 a year throughout the 70s. And what in our submission that tells us is that you can see there was just an increase in the number of officers required to keep order. One also sees that in the statistics for numbers of officers deployed on public order duties annually, which increased from around 20,000 deployments per year at the beginning of the 70s to more than 100,000 by the end of the T1 period. And what in our submission is vitally important is that the inquiry properly appreciates and reflects the realities of public order policing and the realities of disorder. Those realities most immediately were visited upon police officers, the police officers who were required to police those events. And then by virtue of having to redeploy officers from elsewhere, they had an impact on the wider police. Notwithstanding the fact that the police would be wearing, by and large, helmets, the vast majority of injuries that occurred during this period were injuries to police officers. As I say, thousands to police officers and hundreds to civilians. So they bore the brunt of public order policing. And then that, of course, has a knock-on effect for individuals and for society. What we have tried to do in our closing, so as you'll have seen, is to research video footage of some of these events, insofar as we're able to obtain it, in order to try and demonstrate and bring home the reality of what the public order policing situation was. There is limited footage available, particularly from the late 1960s and early 1970s. And so all we can do is put forward effectively a snapshot of some clips of some events. And it's fairly random, fairly ad hoc. There are some significant events that there's no footage of, and there are some more minor events that one can get footage of. But if one views the footage, what it shows is not only police officers being shouted at and pushed and shoved, we see them pelted with missiles and attacked with weapons, so coins, stones, bottles, bricks, staves, marbles thrown under the hooves of police horses, flares and fireworks thrown at the police, flour and paint, ammonia flung in the eyes of officers, petrol bombs used on more than one occasion, various things set on fire, windows smashed, protesters scaling scaffolding, balconies and roofs. So very significant and difficult, physically difficult to deal with situations. There's also, of course, the logistical side of policing those types of events. What we've tried to do to set out in the written closing, and I won't take you through each and every incident, is to demonstrate that between March and October 1968, there continued to be very serious incidents of violence and disorder that were difficult to contain, and that those continued after October 1968. And there were multiple instances of very serious disorder in 1969, 1970, 1971, 1972. We include the Stop the 70 tour as being relevant to consider. Had the South African cricket tour not been cancelled, there would, of course, have been very significant disorder at Test match grounds as the Stop the 70 tour campaigners tried to have the tour cancelled midway through. And that, in our submission, was clearly something that it was appropriate to police and that required intelligence about in order to do that. And that's got nothing to do with being for or against apartheid. It's just a question of dealing with disorder. We then come in the chronology to what we say is a key event, which is in 1972, Idi Amin expelling the Ugandan Asians from Uganda, and Edward Heath's government deciding to admit 27,000 to this country. That event is widely seen as the trigger to the increasing popularity in the 1970s of the National Front. We've given some references to that. It also appears in some of the subversion-related papers obtained from the Home Office and Cabinet Office. That event and then media hysteria and public concern about the implications of it is widely seen as a key vital event in the upsurge in National Front popularity. And what this did was introduce a new dimension to the public order scene. And the reason in particular that it did that was not only because there was moderate opposition to the National Front from mainstream parties and from faith groups and so on, but there was militant opposition to the National Front. And the particular reason for that was that the rise in membership support of the National Front engaged Marxist, Trotskyist doctrine about fascism and racism. So the theory was that as society moves, as capitalism collapses and society moves towards the revolution, fascism and racism can become a way of dividing the working class and thereby avoiding the revolution. And so fascists and racists must be, to use the far left terminology, smashed. They must be smashed on the streets. They must be prevented. And that is in order to ensure that the revolution can then take place. That's simply the theory. And that, coupled with Marxist, Trotskyist theory about the police being representatives of of capitalism and of the establishment and defenders of the system who must also be smashed, generated a perfect storm from the public order perspective of conflagration of factors, and it really became a symbiotic, self-escalating relationship between the far left and the far right, each giving each other a reason to exist, each giving each other something to get excited about, to fight against, and then a tit-for-tat series of events. And what one sees is that throughout the period, the demonstrations and counter-demonstrations between the far left and the far right become the key public order factor, and a very serious one at that. That's the problem, and the legal framework tells us that it was the police's job to manage it. So we then come to the justification for public order policing and for the obtaining in particular of intelligence. It's self-evident, sir, that demonstrations, large numbers of people gathered together, particularly large numbers of people of opposing views wishing to counter each other, have to be policed or they will result in disorder. Doing this without resort to the use of or the threat of plastic baton rounds, water cannon, tear gas is not straightforward. And as we set out in our closing statement, under-policing and over-policing are both problematic. They both have an impact on morale, an impact on recruitment and retention, an impact on the effectiveness of the police, the ability of the police to do other works, and therefore an impact on crime and disorder elsewhere. And I'm not going to read out much of the closing, but I want to read out paragraph 2.2.5. If there had been more disorder and violence during the T1 era, there would have been more damage to property and to people's businesses and livelihoods, more injuries, and probably more deaths. Demonstrations and protests would have been more dangerous for everyone, protesters, police, and others. Even if all public order events had been massively over-policed, the right to demonstrate and protest would have been curtailed. There would still have been disorder and violence, damage to property, businesses and livelihoods, injuries and possibly deaths. And there would also have been more crime elsewhere. And that means more offences against the person, theft, criminal damage. And so either way, individuals and society as a whole would have suffered. So the problem of public order policing isn't simply matching the number of officers to the number of demonstrators, or matching the number of officers to the mood of the demonstrators. It's important that the balance is struck correctly. Under policing will tend to lead to disorder. Over policing has adverse consequences elsewhere. The proposition that intelligence is vital to being able to do this effectively, one can see that the Supreme Court decision of Catt. One knows that demonstrators who wish to cause disorder and whose objective is to smash the police are not going to cooperate with the police and give them the information they need to stop them. That's self-evident. Intelligence is also important for logistics, and one sees in the evidence, particularly the A8 evidence, and also in the videos that we provided, what those logistics looked like. And they were extremely taxing, not just simply pressing a button and having a certain number of police officers turning up at a particular event. There was a need to call up officers, cancel leave, backfill officers called up so that there were other officers to cover the duties they would have been doing, transporting them to the event. They couldn't just all arrive on the bus or the tube, catering, providing toilets, accommodating them, dealing with traffic restrictions, traffic orders, closing roads, bringing the right amount of temporary crowd control barriers. So all of those logistical matters needed to be dealt with, and that required intelligence about what was going to happen and what was needed. And this was not, in our submission, just on an event by event basis. What was needed and what the police needed was an understanding of the public order scene as a whole. So they needed to know who was who in terms of individuals and groups, which groups were related, opposed to each other, allied to each other, likely to cooperate or join in, unlikely to do so, which organizations were really fronts for other organizations, not only what threat would one group pose, but what threat would 2 or 3 or 4 groups pose in aggregate if in the same place. As recognized in Catt, intelligence gathering is inevitably indiscriminate and hit and miss. You can't only collect valuable intelligence. It has to be collected and then assessed. So in order to fulfill its functions, in our submission, the Metropolitan Police Special Branch needed to maintain a large intelligence database. So that the squads in Special Branch could provide A8 with assessments on particular events. And this inevitably meant, as has been referred to, hoovering up a great deal of information that was never used. And you've seen, sir, in the Special Branch files that there were files on local authorities and charities and retailers it wasn't simply about collecting information on groups or individuals who might be of concern. It was about compiling a picture that was cross-referenceable so that detailed assessments could be prepared depending on what the circumstances were. And that picture needed to be maintained and kept updated on an ongoing basis. The public order scene did fluctuate and have peaks and troughs and cycles, and it could flare up in reaction to particular unexpected events. So, for example, internment or Bloody Sunday. And as we said in our first opening at the outset, it's not possible to wait until events have heated up and become more intense and then try and infiltrate groups in order to obtain intelligence. One has to be there on a long-term basis so that when things do occur, the intelligence can be obtained. That so is what we say is the justification in terms of your identification of the justification for the work of the SDS, that there was a public order problem. It's well recognized that policing public order requires intelligence to a certain level of detail, and that was what the SDS was there to do. In terms of whether it contributed to that, whether its work assisted that objective, I noticed that Mr. Barr in his closing said it's difficult to identify an instance when SDS intelligence averted a public order calamity. Now, in our submission, there are a number of problems with this approach. First, the inquiry hasn't investigated whether there were instances where public order calamity was averted. Secondly, it's not possible to retrospectively, or it's not easy retrospectively to work out what SDS intelligence contributed to specifically, because it was kept secret and hidden at the time. It was not, the 8 witnesses were not even aware of the existence of the SDS. So there's no contemporaneous trace of its intelligence and of decisions being taken on the basis of its intelligence. And finally, we say it's not a sensible yardstick. The avoidance of public order calamity is, of course, important, but the avoidance of all of the damage and injury that can be involved in public order is equally important from a public interest perspective. So turning to those 3 matters in turn, first, the inquiry has focused on insofar as it's looked at particular events, it's focused on key disorderly events. So a look at Red Lion Square, Grunwick, the so-called Battle of Wood Green, the so-called Battle of Lewisham, and Southall. Those are the big 5 that have been picked up apart from Grosvenor Square in 1968. But what the inquiry hasn't done, sir, is investigate the numerous number of other large and comparable events which did not result in serious disorder. And we've referred to some of these in our closing statement insofar as we're able to identify them. But there are numerous events during the T1 period which had an obvious potential for disorder, and where this was contained, and where therefore the event isn't remembered in the annals of public disorder history. So following Red Lion Square, there were numerous other confrontations between the far left and the far right. So far right demonstrations usually, not always, and far left counter demonstrations. And there were numerous of those confrontations on a large scale without major violence, major disorder. And we've given details of some of them insofar as we're able to identify them in our closing. So the first is Islington on the 25th of March 1975, where there were 600 National Front demonstrators opposed by 3,000 anti-fascists, and where 1,500 officers, on what we've been able to find, were deployed and serious disorder was avoided. There's Chelsea Town Hall on the 11th of October 1975, where we found some Met Police footage of this. Significant 3,000 counter-demonstrators opposing the National Front's AGM in Chelsea Town Hall. And in the Commissioner's annual report, he says that there was trouble expected, and it was avoided through a very large police operation. Then moving on between the Battle of Wood Green and the Battle of Lewisham, one sees this series of events linking those two major episodes. And one of those is at New Cross on the 2nd of July 1977, where it's clear that there was intelligence that the National Front were going to attack the far left, so an SWP and Lewisham 21 or Lewisham 24 Defence Committee demonstration, and that was avoided. There were 67 arrests, mostly of National Front supporters, and really serious disorder was avoided. And there's reference there to that being the result of intelligence and preemptive measures. We have the Ilford by-election on the 25th of February 1978, where trouble was anticipated, and where the Commissioner decided to ban marches for 2 months in the capital. Now, that decision must have been taken on the basis of intelligence, and significant disorder, violence was avoided, but part of that was the deployment of 5,800 police officers. So a significant proportion of all the officers were deployed to that one event at, in Ilford, about one election meeting, to avoid trouble. And that, of course, required some intelligence as to what could be expected. That ban was then maintained, sir, and was enforced on the 15th of April 1978, when there was a similar meeting in Brixton, near Loughborough Junction, at a school where the National Front held an election meeting. The ban was kept in force. 2,400 officers were deployed, and although there was disorder in the meeting itself, and this is the occasion when HN13 was arrested, serious disorder was avoided. Another event, sir, was at Great Eastern Street on the 24th of September 1978, where the Commissioner in his annual report says he considered a ban. There were very serious concerns about disorder. A ban was considered. One wasn't implemented, but 6,400 officers were deployed, and violence and disorder was averted. Now, again, that consideration that was given to a ban would have required the consideration of special branch assessments, which would have been based on intelligence. And then in Whitehall on the 12th of November 1978, so a Remembrance Day event, 3,000 officers deployed to keep the far left and the far right apart. In Southall on the 23rd of April 1979, this is coming to the death of Blair Peach. It's noticeable that that was one of a series of National Front election meetings that had to be policed within a very short space of time. And the documents show that trouble was expected or needed to be avoided at all of them. So we see Battersea on Wednesday the 18th, Islington on Friday the 20th, 2 demonstrations in Southall, one on the Sunday the 22nd and one on the Monday the 23rd, and then straight away after Southall, another event in East Ham on the 25th of April. And all of those required large-scale deployments of officers in order to avoid disorder. And all of that planning and that work, and one can see in the video of the East Ham Town Hall demonstration, there's had to be 2 days after Southall, there's an enormous camp has been set up in a local park to house all of the officers the police horses. There are crowd control barriers being delivered. All of that's required intelligence. And again, that was an episode which could have descended into disorder, but didn't. Next one mentioned in our closing, 29th of June 1979. There were a number of events that day and almost 8,000 officers deployed on public order duty one single day. Later that year, again, Remembrance Sunday, the 11th of November, 4,500 officers deployed. One sees Southwark on the 2nd of March 1980, 5,300 officers deployed to keep the far left and the far right apart. At Lewisham on the 20th of April 1980, 4,200 officers. And then between Marble Arch and Paddington, the 23rd of November 1980, it's not National Front, this is a British movement march, where 3,400 officers had to be deployed. Now we say these are all examples which could have led to major disorder, or to use Mr. Barr's term, public order calamity, but they didn't. And in our submission, the contribution of Special Branch, relying in large part on SDS intelligence, must have been important to that. And there's been no investigation of those specific events to see what trace there might be in the assessments or matching up special demonstration squad intelligence reports with the assessment.
May I interrupt you there? There has been. I have done it. And I have been able to identify 5 out of your 13 instances in which there was prior SDS intelligence which has survived. In 3 of them, it's 1 report, and in 2 of them, it's 3 reports. There are many reports after the event of what the groups who participated in them were talking amongst each other about. But as regards prior intelligence, only 5 of your 13, on my analysis, appear to have received prior retrieved intelligence from the SDS.
Well, so obviously I can't comment on that because I haven't seen any of the documents, and I'm unable to ask follow-up questions or pursue lines of inquiry. But first, it's not always possible to see which reporting was from the SDS. Secondly, the Special Branch squads were relying on the background information they had in the registered files, which were, of course, contributed to and topped up by SDS intelligence. There was undocumented intelligence and discussions. There were undercover officers on the ground, and it's at this remove of time to say, well, I have recovered some documents. There are lots of documents are not surviving. It doesn't appear that all the public order related documents would necessarily have gone to MI5. It's just that it's, I can't comment on what you've said, but from our perspective, the volume of reporting on these groups, the groups that were involved in the violence and disorder, it's unthinkable that this wouldn't have assisted in the assessments that were provided to A8.
I was simply picking up on your assertion that the analysis had not been done. It has been, and that's something I think you would have wished to have been done. If the retort to the result of the analysis is, well, it's not all going to be there, to a limited extent, I accept that. But it's not, I think, all that helpful to say this proves that SDS reporting contributed to the intelligence significantly, more significantly than the analysis that I've indicated would suggest. For example, on the right wing, there was no infiltration of the right wing during this period, apart from one as a byproduct of a left-wing infiltration, as we know. And it's obvious that there was intelligence on what the right wing were doing. Hence, Chelsea Town Hall, trouble would be anticipated. Or New Cross, where there was trouble, and that there would have been intelligence on the right wing then, as there was. I think you would agree on all major incidents involving left-wing, right-wing clashes that either occurred or were prevented.
Yes, sir. I mean, this is all news to me. You say the analysis has been done, but it hasn't been disclosed to us. I'm not aware of it. Haven't been able to take instructions on it or put it to any officers.
Forgive me, a lot of your officers were deployed at that time. DL clients were deployed at that time, and you've had disclosed to you in full the reporting that they put in and which has been retrieved. So although you may not have had the whole picture, because not all of the undercover officers who were deployed at that time are DL clients, the CL have certainly had the whole picture. And I don't think you can now say we haven't had the opportunity of looking at this. You have had a pretty extensive opportunity of looking at it.
It's very difficult to say take Chelsea Town Hall. It's difficult for us as a legal team to know that was an event where trouble was averted, and to be able to piece together what intelligence there was.
One of your clients did report on the left-wing side of Chelsea Town Hall. He's one of the 3 instances where there's one report.
Very well said. Well, we don't have all the reports. We don't have the undocumented intelligence. And I completely take you saying I don't have in front of me documents where I can trace SDS intelligence to the avoidance of disorder. But it doesn't follow that you can conclude it didn't contribute. And all the other evidence in my submission tells you that it did. And one sees this in the evidence from A8 about the importance of special branch assessments, the vital importance of that. The fact that those assessments were based on files and that were produced by the squads based on what was in the special branch registered files, and that those files were contributed to significantly by SDS intelligence reports. You can also derive it from the fact that the squads helped set the SDS intelligence requirements. So the squads that were required to produce the assessments were telling the SDS what they wanted intelligence on. And they wouldn't have been telling the SDS they wanted intelligence on matters if they didn't need it, or if it wasn't of use to them. But in relation to all of these events, we haven't seen, I mean, even if you say, well, what can we find in that we think was derived from the SDS, we haven't seen the operational briefings, the operational orders, any other documents. I know you say you have an analysis has been done, but it's just not possible for me to comment on that and then to take it away and follow it up. But in circumstances where the special branch squads were providing the assessments and requesting the intelligence in order to help them do so, and saying that they were finding the work of the SDS valuable, it's difficult to think that that could be the case if it was really of no use.
As it happens, we do have a small number, 6 in all, of threat assessments from this period, and it's possible to see to what extent they were contributed to by SDS officers.
Well, I have seen very few, we have seen very few threat assessments. And I take the point was that that's not, they didn't need to be put to DL officers because DL officers didn't see them. But again, it's not something I can comment on.
Well, you and I are in the same position in that we've all seen the documents, and there are 6 threat assessments, and it is possible to analyze the SDS reporting insofar as it contributed to them. The major one is the Battle of Lewisham, but there are others. The first anniversary of the death of Blair Peach, there was a threat assessment there, and it is possible to analyze to what extent SDS reporting contributed to it. All I can do is to look at the evidence that I have got, and when I've got it, when we've all had it, it is possible to analyze it and to draw limited conclusions from it.
Yes, I haven't seen any threat assessments on the events I've just mentioned that had the potential for disorder but didn't lead to disorder.
No, there aren't any there. They've all, if I assume they did exist, they've gone. That's because they were held by the police and the police have not retained them. It just so happens that because the Home Office took an interest in the first anniversary of the death of Blair Beach demonstration, we do have the threat assessments there, and it's possible to compare SDS input into the outcome and to see what other sources of intelligence were. In that instance, SDS reporting contributed virtually nothing.
Was there, I haven't referred to that as being an event with a high potential for disorder where disorder was averted. But there is a difference between saying, I don't have in front of me contemporaneous documentary evidence of SDS intelligence feeding into threat assessments and saying, therefore, it didn't. One has to look at all the surrounding documents. You say, we just don't have these threat assessments. So I don't understand how one can say, well, there's only 3 or 6 or whatever occasions when we can see SDS intelligence contributing when one only has 6 threat assessments.
The other significant one is Southall, the occasion when Blair Peach sustained his fatal injuries. And there is a very careful threat assessment. The prior reporting, such as it is, there is some evidence about that. And it is plain, if one compares the prior reporting with the threat assessment, that the threat assessment did not rely to any significant extent, if at all, on SDS reporting. All I'm doing is pointing out in the limited instances, 1 or 2 of them of some significance, where it is possible to make the analysis. It doesn't bear out the wider proposition that you're seeking to advance.
Well, so there's what you can derive from fragments of surviving information about a handful of events. The Southall was unusual because it involved also demonstrators from the local community, and the same as at the Battle of Lewisham. So those are factors that obviously the SDS didn't report on the Indian Workers Association or the more militant youth group that was behind it in Southall. So there may be reasons for that in particular events, but the overall picture is of thousands of events. And to take 6 threat assessments relating to slightly unusual events or events where there was disorder and extrapolate conclusions, in my submission, it isn't safe. I see the difficulty you're in, but one has to consider, again, in my submission, the surrounding evidence, the special branch squads providing threat assessments, and we have very few of them left. Requesting intelligence from the SDS in order to help them do so. they wouldn't, in my submission, have done that if that intelligence wasn't helpful to them. And just the way in which SDS intelligence isn't necessarily, it doesn't travel with an SDS stamp on it, unless it's kept by MI5. But you've seen the evidence from those in A8. They didn't even know there was an SDS. So in my submission, it's one thing to say, I don't have lots of pieces of paper telling me that here's an occasion when the SDS averted public order calamity. But it's another thing to say, therefore, it didn't, when it was providing a high volume of information about the groups involved in disorder.
To ensure that the picture is fairly placed, there should be put on your side of the equation the reporting before the Battle of Lewisham, which was extensive and did include a good deal of SDS reporting, which informed both the Commissioner's decision not to ban the National Front March and the tactical deployments that took place on the day.
So yes, and we again, the difficulty is to take these. Well, it's difficult to say that something went wrong at Grumwick, but particularly in relation to the other four, the episodes where there was serious disorder and violence, and there are fragments of information left behind, and then to say that was the totality of the picture. And we know that in relation to the Battle of Lewisham, there was a lot that the officers involved, and in relation to the Battle of Wood Green, who were there, and who were able to report on where bricks were being piled up and so on.
Indeed, I heard their evidence. I believed it, and I do not for one moment doubt that what they fed into the intelligence picture was of value to those who were attempting to police these events. Now, only point in putting these specific propositions to you was to suggest that SDS reporting was only part of the picture, and that insofar as it is possible to analyze what's been recovered, not always significant, sometimes yes, quite often no.
And for a huge number of events, just unknown. But I mean, I take the point that the special branch registered files were not populated entirely by reports from the SDS, that there were reports from intercepts and other sources and other research and inquiries in amongst them. But what one has in particular with the far left groups who wouldn't cooperate with the police and who were infiltrated by the SDS is a valuable and reliable source of intelligence on their intentions, numbers, mood, and so on. And if the SDS intelligence wasn't helpful, it just doesn't make sense that the special branch squads were still requesting it and saying it was helpful.
Before we cease this exchange, can I put one further proposition to you, which stems from an analysis that I've undertaken of special branch, SDS reporting for a period, as it happens, it's 1975 to 1978, the 3 financial years which span Battle of Wood Green, Battle of Lewisham, and deal with the time when the future of the SDS was being considered internally. It suggests that rather over half of the retrieved reports, not a lot over half, but a little over half, are reports about individuals, their names, addresses, lives, families, political views, and so forth. Of the remainder, just under half, only about 7% or thereabouts appear to cover reports about forthcoming events that might give rise to a public order problem in London and elsewhere in the country. And it doesn't look from the retrieved reports as if the great percentage had anything to do with forthcoming public order events.
Well, again, so I can't comment on that because I haven't seen your analysis and I haven't seen what it's based on, and I don't know how complete the retention was. My understanding is that unless it came from MI5, there was very little left. But the way in which inevitably in pre-computerization the special branch intelligence system operated was to have a large database of files that could be cross-referred and pulled out so that those on the squad desks could know what was going on, and they could also get further information on the phone and meetings and so on. And what the SDS contributed bolstered, fed into those files and that knowledge base. And that was all, in our submission, important. And that's just the nature of intelligence. And there may have been information that proved irrelevant and never went anywhere, but it was maintained so that there was not in the possession of one individual, but organizationally a corporate brain which understood the public order scene and was able to assess what might happen. Of course, imperfectly, it's going to make mistakes, get it wrong. There might be occasions where it wouldn't be acted on. But on the whole, it was a system which worked. And what one sees is from 1968 onwards, A8's established, the SDS is established, and by and large, notwithstanding this huge antipathy between the far left and the far right, public order is maintained. And in our submission, one takes from what the A8 witnesses say about the value of the intelligence, what the desks and the squads were saying about the value of the intelligence was that it contributed. And that's I appreciate it's difficult. You have very little to go on, but it's just a common sense conclusion to draw from the evidence. And I would like to see the analysis and see what it was based on and contribute to it. But it sounds like you're lifting a curtain on what's going to be in your interim report, and it's all news to me. Well,
in the period I've canvassed, the 3 years, your DL clients represented a majority of the officers who were reporting at that time. And you've had full disclosure of that to you, and you can tell from their own reports whether my own order of magnitude is roughly right. I'm not claiming precision for these figures, but simply to try and get at an order of magnitude. And I'd be surprised if the order of magnitude that I've arrived at is very seriously out.
Well, I can't comment, sir. And I think that to do the exercise, one would really need to see is the threat assessments and the A8 files, and to see how they fit together, and also to know what was passing backwards and forwards that wasn't put into intelligence reports, reports that maybe weren't retained, and so on. But I can't. You say that there's analysis of these financial years and these are the statistics. I mean, I just can't comment on that.
No, but I mean, you could, if you had thought it was worthwhile, and you may say it's not worthwhile, but you could, if you thought it was worthwhile, do it on the basis of the reports produced by the officers that you represent.
I really can't, because we are not in any way comparable to the inquiry legal team. We're a very small, not particularly well-resourced group representing individual officers. The Rule 9 witness packs we get are subject to a restriction order, which means we can only discuss the contents of any one witness pack with the relevant witness. And it's just not possible for me or for my team or Ms. Castiglione to undertake analytical work of that kind. Or we could comment on it if it were disclosed to us. We could maybe contribute to it, but I mean, we can't run a mirror inquiry.
So there wouldn't be any point in undertaking now a further disclosure exercise to you, because all it would show would be that what you already had is roughly representative of the rather larger figures for those that include undercover officers who are not your clients. So there wouldn't be much point, it seems to me, in from what you've said, in piling you with further documents which you wouldn't be able to analyze.
No, sir, but I mean, there would be a point in sharing the analysis or allowing us to make representations on it, or all of the core participants to make representations on it. And in those financial years, what one sees, what I'm able to see from the Commissioner's annual reports is a consistent concern that public order is draining the resources of the Met. It's deterring recruitment. It's having an adverse effect on retention. It's a serious problem, and anything that can be done to ameliorate, to mitigate that, any obtaining of intelligence, and the SDS was, you know, in the grand scheme of things, as we've set out in our closing, didn't cost much to run. That could contribute and could help and could have significant public order benefits in terms of how public order events were policed and what happened at them.
Forgive me, I've interrupted you enough, and please let me get you back to your thread.
Thank you, sir. That's what we say, the justification. And we do say that the idea that because we don't have particular examples or that many examples of an SDS intelligence report averting what Mr. Barr calls a public order calamity, does not mean that it didn't make a contribution and wasn't valuable. And for the reasons I've said, the surrounding evidence, it all points in the direction of it being of value and being of importance. So moving next, sir, to the adequacy of the public order justification. And we accept that some deployments were discontinued or not renewed, that there was always a risk that there would be a deployment that wouldn't yield anything, because you can't know until you're obtaining intelligence whether it's of value. But accepting that caveat, there was a need for intelligence. The special branch had available to it a method of obtaining that intelligence. The European Convention on Human Rights wasn't incorporated into domestic law, so there was no obligation to undertake proportionality assessments. It was the special branch, like MI5, was entitled to take a broad brush precautionary approach as a matter of policy in terms of what did it think would help it, or what did the Met think would help it, policing public order and containing this significant problem. The Commissioner obviously had the duty to maintain public order. He had a duty of care to protect his officers and to try and ensure recruitment and retention and allocate resources effectively. As we said in our closing, I recognize that general considerations of resources and effectiveness and of avoiding consequential knock-on effect on other community policing and so on, that they're difficult considerations to place in the balance against the impact of undercover deployments on the real lives of specific individuals. And I accept also that you must look at that impact, the impact of the deployments and of intelligence gathering on individuals who were involved in public order events. But it wasn't simply a question of individual rights versus generalized public interest considerations. On that side of the equation, we say, and one can see it in the video footage that we've tried to obtain, one sees police officers on the ground, police officers with blood streaming down their faces, police officers in hospital beds the day after being attacked at a demonstration or a protest. One sees the statistics of 1 in 10 of the officers deployed at Lewisham sustaining injuries. These incidents, whether it's being spat at or shoved or pushed or having a brick smashed in your face, are not part and parcel of being a police officer. They're not something that police officers must simply endure. The police are citizens in uniform. They are entitled, they have the same human rights as everyone else. You, sir, and your team do not travel into the inquiry's offices wondering if you might be spat at or punched or kicked or hit with a brick or have ammonia thrown in your eyes or attacked with a petrol bomb. No one should have to travel into work wondering if that's going to happen. But that was the reality for officers attending public order duties. I'm not talking about TUC or CND or pro-choice, large-scale, moderate marches, but attending public order duties in the 1970s where there were demonstrations and counter-demonstrations with one side determined to silence the other. And it wasn't, of course, just police officers who were affected. It was their families. And one can well imagine how it would feel for the child of a police officer to be told, well, Daddy's not coming home tonight because he's in hospital because at work he's been hit with a brick or beaten to the ground. That has an impact on the private lives of those families. Whether or not these are to be characterized as public order calamities, their avoidance is important. It was right that the commissioner did everything within his powers, as he was at the time, to try and minimize the number of injuries to officers and also the number of injuries to members of the public, and then keeping the peace generally. These are all important considerations that need to be placed in the other side of the balance. So one does have the impact on activists who were reported on, but one also has the greater impact on those who might have been physically or psychologically injured had public order policing been less effective. So in terms of the adequacy of the justification, it's a policing judgment for the commissioner and for the force, as it was at the time, to come to a view on. But in our submission, that is an adequate justification, bearing in mind what the legal framework was and bearing in mind the consequences, the very real consequences for those who might be hurt at demonstrations if they weren't better policed and if there weren't better intelligence on them. And it is of concern to my clients that this factor doesn't seem to sound or resonate in any documents we see coming from the inquiry. There's rightfully a focus on those who were impacted by deployments. But what's in the other side of the balance, which is not just resources and public interest considerations, it's real impact on real people who are simply trying to serve the community and trying to ensure that those who aren't interested in Marxism or fascism are allowed to live their lives in peace. So we get that having an undercover officer in your home or at a meeting or a social event, not knowing who they are, that's an impact and that's an intrusion. But so is being spat at and punched and kicked and injured. and all of the impact that that had on police officers' families as well. And for those reasons, we say that there was a justification and it was adequate. It was in the range of reasonable responses for the Commissioner to the special branch as a whole to take the approach that it did. That's on the public order side of the equation, sir. Turning to the secondary justification, in terms of your terms of reference, identifying what the justification was and then assessing its adequacy. The secondary justification was the counter-subversion justification. So in this area, MI5 had primacy as a matter of competence and expertise and responsibility. The approach to subversion was set by MI5, and that was a national security assessment. The task of special branch was to assist. And in our submission, it's unrealistic, it's unreal to suggest that special branch or the SDS could or should have gainsaid or disputed MI5's assessment. It simply wasn't its place. It didn't, as I say, it didn't have the competence or the expertise to do that. All the officers who were asked what's the definition of subversion, the bottom line was that the definition of subversion was what MI5 said it was. The groups MI5 treated as subversive were to be treated as subversive. And one has this kaleidoscope of definitions moving around in front of our eyes when it comes to this. So there's the Maxwell-Fyfe definition, the Denning definition, the Harris definition. There's a document referring to the Rough and Ready definition. In our submission, what's important is to see that there were these nebulous definitions. There was this grey area, and not to grab hold of and cling on to one definition and use that as a basis for testing everything that happened. It's to appreciate that it was for MI5 to set, and it took the approach that it did. The inquiry hasn't investigated, apart from the statement of witness said, investigated what the justification was, what the concerns were. You and your team have rightly identified various threads and that may or may not have been in play, the extent to which state sponsorship was or wasn't important. But whatever the Harris definition may have said, and whatever the appropriate meaning of that and its sort of two limbs is, special branches were told by the government and by MI5 to look at potential and future threats and to treat those as subversive. And one sees that in the classified confidential covering letter that went with the new special branch terms of reference. It's important in our submission that the Harris definition was not a statute and was never seen internally as prescribing what could or would or should be done. And the approach of Mr. Barr and his team is to focus on whether the practice fitted the definition, and if it didn't, to say the practice should have been stopped. But that could equally be turned on its head and to say whether the definition should have fitted the practice, whether the definition should have been changed. There's in fact three possibilities. One, if you don't think that what happened really fell within the four corners of the Harris definition, one possibility is you change the practice and you investigate fewer groups. It's inconceivable that MI5 would have supported that at the time, or that the Home Office would have done. The second possibility is you change the definition. And the third possibility is you either you don't have a public definition, or you just proceed on the basis that it doesn't matter whether the theory and the practice are entirely aligned. And it's important contextually to bear in mind that at this point in time, national security matters were seen very differently to how they are seen today. This is before there was a Security Service Act, an Intelligence Services Act. National security matters were seen as non-justiciable. They were never considered by courts. There would be ministerial conclusive certificates if they ever became relevant to anything. And they were seen as secret. And what we say about this is nothing to do with questioning proceedings in Parliament. It's nothing to do with what Lord Harris knew or said or did in the chamber of the House of Lords. This definition was published more widely than just in Parliament. The important point is that the Home Office and MI5 told the special branch what to do, all the special branches what to do, and they did it. And as we've set out, 28% of MI5's work in the 1970s was on subversion as it saw subversion, as it assessed it. And both MI5 and Special Branch were involved in a huge number of vetting inquiries. So that was the justification from the perspective, particularly of the SDS and of the police. In terms of the adequacy of the counter-subversion justification, in our submission, sir, it's facile to say that those treated as subversive or potentially subversive did not present an existential threat to the state or were incapable of toppling multi-party democracy. That isn't the test. It's not simply just could this group bring down Parliament. First, that's hindsight, and was something that couldn't be verified without investigation of the groups themselves and the knowledge of what their capabilities were or weren't. Secondly, it was something that would never be a one-off assessment. It was something that MI5 would always need to, it was a dynamic and evolving assessment, something that MI5 needed to keep on top of. A group might be incapable of really producing any significant effects one year. It might not be receiving state sponsorship or what have you, but it might change the following year. And MI5 is responsible for national security and is entitled to take a precautionary approach and to keep on top of that. It's important to bear in mind also the Cold War, which was clearly a factor. We haven't been able to explore with MI5 why or to what extent the Cold War was a factor, but one can see that when the Cold War came to an end, the approach to subversion changed radically and was scaled back. And crucially, the national security assessment of MI5 isn't something that the inquiry has been able to investigate. And so therefore, from the police perspective, it was an adequate justification. They were doing their job. Whether underlying that, the national security assessment was right or wrong isn't something that any of us can confirm or deny. That's all we say about subversion, sir. We've dealt at the end with a number of specific issues, and I'm just going to deal with 3 very briefly and then just touch on the remainder in just a sentence. So the first is the extent of the personal information recorded in and the language used in intelligence reports. As I've already mentioned, the way in which a paper-based intelligence database needs to work is that there is a hoovering up of a large amount of information. And that's simply inevitable. That information was not shared widely. It was used internally by Special Branch and it was shared with MI5. So in terms of the proportionality of its collection, in my submission, that's something that can't now be criticised. Mr. Barr says in his closing that the reports contain racism and sexism. I don't know specifically what he's referring to. We see in the reports contemporary attitudes and contemporary language, but nothing in my submission out of keeping with the time, with society in the 1970s. As for the point made about tone, tone is, of course, something that's easier to hear than to read. In our submission, a sense of humor is not unprofessional. It is, of course, the case that attempts at wry remarks or jokes can fall flat, and particularly when read after the event. But that doesn't mean that the person writing it down is acting unprofessionally. Mr. Barr, of course, is an avid reader of Private Eye, sir. His subscription fully in force, and there's the long-running joke in Private Eye about judges making jokes. Good one, my lad. People make jokes. They use sarcasm from time to time, and it doesn't mean that it's unprofessional. It can look a bit off, but that is just, in our submission, life. And we do say that it's quite difficult to square counsel to the inquiry repeatedly referring to the SDS's targets as a bad joke, and seemingly enjoying that label, to square that with the claim that occasional sarcasm about those targets was unprofessional. It's just part of normal life.
Forgive me again for interrupting you. The bad joke is Sir Robert Mark's words, and that's why it features.
I know. Yes, of course, it's come from his memoir, and I understand that's primarily about his time as Chief Constable of Greater Manchester, or maybe it's Liverpool. But the label has been adopted in Mr. Barr's closing, and I think in his module 2B, B to C, opening as well, as applicable to the groups. So it's been used as a basis for saying for trivializing or belittling what the SDS were doing, it seems to me, and it's not flattering. Not everything in the intelligence reports was flattering. Not everything that some of the groups that were reported on by the SDS did was deserving of flattery. And one sees in some reports, there are reports saying that such and such a speaker was boring or difficult to understand. That may have been useful intelligence, and there are equally bits of reports which say someone was a very effective or powerful speaker, a good orator. And that's helpful to know, because one can see whether or not they're likely to rise and go further or not. So it's really, in my submission, scraping the barrel in terms of trying to find criticisms to make against those involved who were public servants doing their best to say, well, they were sarcastic and so they were unprofessional. There's no language in the reports, in my submission, that one doesn't find in judgments at the time, and that wouldn't have been commonplace in all other walks of life in the 1970s. And words like racism and sexism are such slur words in our society now that bandying them around in order to denigrate people who simply were living in a different time and subject to different expectations in a very different society with a different demographic profile, to smear them with those words, in my submission, is highly unfair. I mean, just as someone who did pupillage in the mid-90s, I heard a lot worse, and that was at the bar, and that wasn't right. But in terms of what's in these intelligence reports, it was simply in keeping with the times. The second point I just want to touch on is in relation to children. There seems in my submission to be a certain amount of confected outrage about the fact that intelligence reports included information about children. The government funded the education system. It did so in order that children could be educated. It paid the teachers. Children went to the school to learn and develop, not to be recruited to extremist ideologies. And it is a fact that both the SWP and the National Front actively sought to recruit other people's children to their causes. That's a proper subject for the state to be concerned about. It's paying for this system. Is it being used? Is it being abused by outsiders? I simply do not see why that's thought to be objectionable to mention someone who's under 18 in an intelligence report, and to turn a complete blind eye and not investigate it would have been, in my submission, an abdication of responsibility. There was no reason to allow the state education system to become a recruiting ground for extremists. It's not what most parents would have wanted. So in our submission, that's a proper subject for reporting, and there was no rule that you should not report on someone under 18, and there was no reason to have such a rule. The school leaving age was even younger than 18 at the time. So the third and final matter, just to address you on under this heading in a little more detail, is just in relation to, I'll take political neutrality and justice campaigns together. As you've mentioned, that the SDS did not report on the far right in the T1 era, initially because it didn't pose a threat to public order, and then after the National Front's increase in popularity, because it was covered by other sources. It would, in our submission, have been unlawful and wrong for a special branch or the SDS to try and judge or identify righteous causes and to treat them differently, to allow anti-apartheid campaigners more leeway than others. It's a politically neutral process matter to maintaining public order. It doesn't matter to the police who's arguing for what. It's just a question of them ensuring public tranquility. In terms of specific justice campaigns and anti-police campaigns, again, there's no rule against reporting on them or collecting intelligence on them. It must, of course, depend on whether they might present a risk to public order. But the police can't treat them differently. I mentioned in our submissions the Mark Duggan case. That was an anti-police incident that escalated into serious disorder. It couldn't possibly have been right for the Met to say, well, we're not going to police this. We're not going to try and gather intelligence on this, because it was the action of a police officer that may have sparked it off. One sees that in the 1970s with the Lewisham 21 or Lewisham 24 Defence Committee, which was heavily targeted and used by the SWP and became wrapped up in the build up to Lewisham, the period of time between Wood Green and Lewisham. It's inevitable that public order intelligence needs to, on occasion, cover groups of that kind. So far as concerned East London Workers Against Racism, that simply wasn't a justice campaign. It was a largely white Revolutionary Communist Party front organization looking to recruit minority support for the reasons, going back to Marxist Trotskyist theory, that racism, it will be used to divide the working classes and to prevent the revolution. And we say it's not remotely comparable to the Stephen Lawrence campaign. And it was MI5 were interested in it, and it was legitimate to report on it at the time. The only point I wish to make about the the Friends of Blair Peach or the Blair Peach funeral and related demonstrations was that they were major public order events. They had heavy SWP, ANL involvement, and it was inevitable that they would be covered. In relation to the funeral in particular, that some of the questions put to officers seem to imply that they had attended a small private family funeral in a church. The funeral itself, and we produced some footage of it, it was attended by 1,278 police officers in uniform and 5,000 to 10,000 mourners. So it was a major event. Roads had to be closed. I'm not saying it did, or even that it might have resulted in disorder, but it was something that the Metropolitan Police needed to be aware of and to consider. I'm not going to address you in detail, sir, on what I've said on other topics. This is at the end of our closing. Elected representatives, that's simply tangential, unobjectionable reporting in our submission. Positions of responsibility within groups is just a question of the need to differentiate substance and form, and to apply Conrad Dixon's firm line between leader and follower. There were secretarial, treasury type, quote unquote, positions of responsibility, but they didn't cross the line. Leave aside the Rick Clark case, they didn't cross the line between leader and follower. You've got our submissions on participation in crime and agent provocateur and the circular. We've already addressed you on the minimal resources that were expended on the SDS in the grand scheme of both Special Branch and Met Police expenditure. I have nothing to add on cover identities, really, from what we've said in previous openings. I've set out some points on sexual relationships. We do say that there's a difference between casual sex, one-night stands, and relationships going further than that. That doesn't mean the former is excusable. The 3 clients of mine who disclosed that they'd had one-night stands accepted it was wrong. We've given you some points of detail on HM 106, HM 126, and HM 155. Then the only point just to raise in this regard, sir, is just the Mr. Barr's statement that sexual contact between undercover officers in their undercover identities and members of the public was not uncommon. We say that's an exaggeration. There was, on the evidence, there was none at all during the T1, P1 period. And if one compares the overall number of officers with the number of incidents, it's an exaggeration to say it was not uncommon. That may change once one gets to the T2 and T3 eras. But in fairness to the SDS as it was run in the 1970s, that not uncommon would give an impression that isn't really borne out by the facts. That's not to say that the incidents that did happen weren't wrong or regrettable. It's just a question of quantification or how to describe it. Then there's just the linguistic point about the meaning of embarrassment. So those are my substantive submissions in closing on particularly public order and subversion. I just have the legal framework to deal with. I'm just going to glance at my watch to see how we're getting on.
If you want to pause, you have plenty of time still. By all means do. But if you can complete comfortably, please do that as an alternative.
I'll press on because I don't think it's. I've set out the submissions in some detail, sir.
Yeah.
I'm not going to attempt to address you as if this were a judicial review. There's no bundle of authorities. I'm not going to take you through the dicta of Lord Justice, whoever. Just focusing briefly, sir, on trespass to land and breach of confidence. These seem to be the two main areas that have been suggested as matters for the inquiry to address. And in our submission, it would be unlawful for the inquiry to do that. There's three reasons, and I think I'm fairly well aligned with Mr. Skelton on this. Three reasons in our submission. One, your terms of reference do not allow you to make findings as to lawfulness, civil liability. Two, your powers under the Inquiries Act also do not allow you to do that. And three, the arguments themselves are misconceived and wrong. In relation to the terms of reference, you're obliged, the inquiry is obliged by section 5.5 of the Inquiries Act to act within the terms of reference, and they do not include lawfulness. And in our submission, the way in which justification is included doesn't allow for determination of lawfulness as a facet of that. So what the terms of reference provide is that the inquiry should identify the justification. So what was the police's justification at the time, and assess its adequacy. Was that justification adequate? Did those involved at the time take the justification they had and act reasonably? That was the approach that Sir Christopher signalled at the outset. That was the approach that's reflected in the issues lists. None of the Rule 9 requests that our clients received were directed to considerations of lawfulness, anything to do with trespass to land or breach of confidence. None of the Module 1 witnesses were asked about lawfulness when they were questioned orally. And when it came to the issues lists, the inquiry went out of its way to make the point that deception, the effect of deception on consent in the context of trespass to the person and sexual relationships, was something that would not be determined by the inquiry. As far as we can tell, no one had in fact urged the inquiry to include that as an issue, but nevertheless, it went out of its way to say that it wouldn't be appropriate. In our submission, there's no rational basis for treating trespass to the person and trespass to land differently, or for treating trespass to the person and breach of confidence differently. These are all issues of civil liability, and they fall outside the scope of your terms of reference. I understand the logic of the position that says, had it been the case that there was no power to do what was done, then that couldn't have been justified. But that doesn't then entitle you to go on and determine whether or not there was a lawful power to do it. That's, you could say, if there was no power, then it wouldn't have been justified, and anyone could understand that. But that doesn't then allow you to go outside the scope of the terms of reference to determining issues of civil liability of the officers or of the police itself. So just on section 2, there are in fact no authorities on the meaning of section 2 of the Inquiries Act. There's the one Northern Ireland permission decision. And in our submission, there's no authority for the view that section 2 allows the exploration or determination of contentious and untested legal arguments. Public inquiries into fatalities are slightly different. particularly when they're held in lieu of an inquest. Inquests are even further removed from Section 2 of the Inquiries Act. Reference made to the Pounder decision does not support the argument that public inquiries can determine issues of civil liability in this way. In fact, Pounder is completely irrelevant. Rule 42 of the Coroner's Rules, 1984, played no part in the decision-making of the coroner that was subject to judicial review in that case, and it played no part in the decision of Mr. Justice Blake in terms of the outcome. The possibility of an unlawful killing verdict in that case wasn't raised. It was simply a question of the coroner agreed that the appropriateness of the force used should be left to the jury, but he thought that that should be done without guidance as to the law. And Mr. Justice Blake said the jury should have been given that guidance because it was crystal clear that the officers concerned didn't have a power to restrain Adam Rickwood. Rule 42 is only mentioned obiter in connection with a side argument about whether or not questions about legality might have raised the need to give self-incrimination warnings that might have inhibited people's evidence. So Pounder takes the matter no further, and in our submission, Section 2 means what it says. Coming thirdly to whether or not the arguments are sound, the arguments about trespass to land and breach of confidence, we say they're not. In relation to trespass to land, there are two questions. What was the physical act? Where did the person go? What did they do? Not what was their identity or their motivations or what were their objectives? And was that physical act permitted? In this context, in all of the authorities, purpose, in terms of the purpose of going on the land or doing something on the land, is only ever used in connection with what was physically done. It's not purpose in a subjective sense of ulterior purpose. There's no authority for the proposition that fraud or deception is capable of invalidating, negating, nullifying or vitiating a license to enter. The inquiry is always and only as to the scope of any express or implied license and whether this was exceeded by the visitor. And one can see that in the case law. Some of the case law, is postdates the Tranche 1 period. But it says the exact opposite. Whitaker and Clarence both make clear that that fraud and deception don't, as a matter of law or fact, vitiate consent. Archbold doesn't say anything different. The fake gasmen cases do not turn on the fact that there was some deception or pretense. They turn on the fact that the relevant people were there to steal, not to read the meter. And as for Smith and Hogan, it's wrong in saying that there's a difference between the Australian High Court decision in Barker and the Court of Appeal decision in Byrne. In Barker, the majority expressly refer to and rely upon and say that they're following Byrne, and so the editors of Smith and Hogan have just got that wrong. And one can see how that's happened because their focus is in relation to mens rea and what the defendant's mens rea may have been in terms of realizing whether or not the person letting them on land had made a mistake. The law on trespass to land is and is intended to be straightforward and to involve a factual inquiry about scope of license and whether that's exceeded. And there are a number of reasons for that. First, it's a tort that's actionable per se, so it needs to be clear whether or not the tort's been committed, and that it affects the duty of care. So the Occupiers Liability Acts apply differently depending on whether you're a trespasser or a visitor. Furthermore, any case of trespass to land has to be decided on a case-by-case basis on the facts. So one has to consider first, what was the license? What are the terms and limitations, if any, of the license? How general was it? and then what did the individual on the land do? Where did they go? What did they do? So it's not something that can be dealt with as a matter of general theory. And then finally, this has never been tested in the context of undercover officers or covert human intelligence sources. And so there are public interest justifications, leaving aside whether or not a license has been exceeded, that have just never been ventilated by the courts. And it's not possible for this inquiry to predict or anticipate what the result of adjudication on those matters might be. And all of this has implications for not just undercover officers, but other people who are not telling the truth about who they are or what they're doing. Anyone with an ulterior purpose, undercover journalists, undercover activists. It has implications in numerous other areas, and all of that has never been tested. I'd say no more about the law on trespass to the person. In my submission, what one gets from the case of Monica and DPP is an obvious conclusion, but in any event, the law treats land and bodies differently. Just in relation to breach of confidence, in my submission, Malone, the decision of the Vice Chancellor, gives a good indication of what the courts would have made of the claims of breach of confidence if they'd come before it in the 70s. But even post Spycatcher and post Immerman, there's no basis in our submission for saying that collection of confidential intelligence by the police is unconscionable or necessarily constitutes a form of misuse or is in any way ultra vires. Police and journalists and others are generally free to obtain information and then decide what to do with it. And there may be obligations that arise at that point as regard onward use, but it all depends on a case-by-case analysis of what's the information, what's the nature and extent of the actual or apprehended use, what's the public interest justification, how does this bear on the conscience of the proposed or actual defendant. And there's a wealth of case law establishing that the police can obtain and use confidential information in order to discharge their functions. So we see LOL, ex parte AB, Woolgar, and CAT. And consistently with this is the line of authorities providing that non-police confidants are generally permitted to disclose confidential information to the police for follow-up. And it's not a breach of confidence for them to do that. That's what I say about breach of confidence. The final matter I just want to address you on very briefly, sir, is just a fallback argument that seems to have emerged in CTI's, in Mr. Barr's recent submissions, which is to complain, well, there's no evidence that those involved at the time considered the legality of the tactics, considered whether or not there was a trespass to land or a breach of confidence. And in our submission, it's not fair to raise that now without having investigated it, without having, apart from some last minute questions to T1, P3 managers, consideration given to legality is not something that the inquiry has looked at, and it's not fair to complain now that there's no evidence. I don't know whether or not thought was given to it, but what we can say is that in the 1800s, the Poppe report confirmed that undercover policing was valid, and that at this time in the 1960s and 1970s, police officers generally knew what their powers were and sought to act in accordance with them. One sees that in relation to the Malvina case, Matt Roger addressing the court. Police officers were fairly familiar with legal matters at the time. And in terms of no evidence of the SDS or special branch considering questions of legality, it didn't occur to anyone involved in the inquiry for 7 years that entering private premises with the ostensible permission of the occupier might be a trespass to land, or that obtaining intelligence might be a breach of confidence. And if it didn't occur to Mr. Barr and Ms. Kaufman, in my submission, it's unfair to say that it should have occurred to those running the SDS. And there was a very good reason why it didn't occur to them. There's simply no basis for the claims. It's just flying a kite to suggest that going into private premises without saying who you really are or why you're really there might be a trespass to land, or that a police officer collecting confidential information might be an actionable breach of confidence. And in that regard, it's important to remember that the 1960s, the 1970s were much less litigious times and very different to now in terms of public authorities consulting lawyers or taking legal advice. I don't know if you'll remember, sir, but it's not in Wade and Forsyth now, but earlier editions of Wade on administrative law made the point that there were very few lawyers in government, apart from technicians dealing with drafting. And it's after the Tranche 1 period that one sees the reform of judicial review and the explosion of judicial review, the introduction of the judge over your shoulder book to the civil service. The culture in terms of running things by lawyers was very different. It's well after 1982, well after the Tranche 1 period, it was still the case that MI5 and MI6 shared one lawyer, and there was a person at GCHQ who had apparently done A-level law. They were very, very different times there. And to say now that Conrad Dixon didn't go down to see counsel to take advice, it wouldn't have occurred to him. It just simply wouldn't have been part of the culture. It may well be different now, but again, it's an instance of, with hindsight, criticizing people for doing things that are done now with very good reason, but in very different times. And then one last point, just in relation to Article 8, is just to flag that in our submission, there's no point, that it serves no purpose for the inquiry to point out that the regulation of or the statutory regulation of undercover policing was lacking and didn't meet the in accordance with the law test, because one knows that now. It's clear from the Strasbourg authorities and from the legislation that was passed in consequence of those authorities. In the 1970s, there had been, as we've set out in our closing, there'd been very few decisions from Strasbourg in relation in cases involving the United Kingdom. The jurisprudence was very early on in its development. The government in Malone, which came later, still argued that interception was in accordance with the law. Class only came out at the end of the 70s. So all of that is not really something that the inquiry needs to comment on, but it's worth bearing in mind that when it comes to proportionality, the Asbesta decision of the Commission upholds the proportionality of MI5 and Special Branch maintaining intelligence on potential extremists and subversives in the interests of national security. And in that regard, in relation, and that's for vetting purposes, and it's important when it comes to vetting. This goes back to the subversion point that, well, these individuals didn't have power to threaten our institutions or to threaten the state. If you give someone with no power highly classified information, you give them the power to cause damage, and that's the reason for having vetting. So there are some people unable to do anything to subvert or undermine parliamentary democracy, but who would be able to cause it real damage if given highly classified information about defense or intelligence. And that's something that the vetting system was and still is in place to catch and to avoid happening. And lots of people will be in vetting files who are never vetted, and lots of people will be in vetting files who pass their vetting. But that doesn't mean that intelligence shouldn't be collected. So I will leave there well in advance of 5:20, and I'm grateful for your time. I shall look forward to seeing the interim report.
Thank you very much, and especially for finishing within the 2 hours that you were allotted, and indeed with a bit of overrun if you'd wanted it.
Yeah,
grateful to you.
Thank you.
And please get back to your break.
I will do.
Thank you. That concludes the proceedings for today. We're going to start, I think, at 10 o'clock tomorrow morning, and we will have quite a lengthy cast of what will be shorter submissions.